So what do we suggest today? Well, what we're suggesting is not taking to the streets, right? What we're suggesting is to either send an oath of allegiance to one of the barons, or if you're not comfortable doing that, declare your standing to either an alleged authority, like a chief inspector or a manager of a court or whatever, or a politician. You can declare your standing in Article 61. You can put it in a document, a notice of conditional acceptance, a notice of lawful objection. I'll just explain quickly a notice of lawful objection, because if you've got nothing coming after you, you've got no claims against you, no demands being made against you, and you really want to get off your arse and actually put Article 61 into effect, you can lobby the local police chief inspector, state your standing, provide a copy of your oath, and ask if there's any objection to your standing, because you don't want to come into conflict with the policy enforcers. And you can get a little process going there. The premise behind using notices on public officials, alleged officials, is to educate. That's formally what we're trying to do here, is to educate people en masse. So if we send notices to them, we're being honourable, we're giving them a chance to remedy the matter, we're giving them a chance to understand Article 61. And so if more of us are doing this, the word would be getting out there a lot quicker. And if they don't agree, or if they lie or ignore us, then we can go after them a bit further, as I said earlier, with notices of treason. And that gets them, gets them either backing off or talking to you, we hope, in future. So far, they're just backing off. So, but that's the remedy. They back off. They want you to go to court, and you hit them with this stuff, and they back away. And the summons goes away. The prison sentence goes away. And that's evidence fact. This is all I'm saying. We're using this process, and it works. We don't go to their courts, because to do so, we're giving consent to their courts, even by standing in there and saying, well, you've got no jurisdiction. We've actually given consent to it by walking in there. But there's another way of thinking about that. We can use their corporate hearings if we go in as a claimant, but only if we're standing under Article 61, if we're in lawful rebellion, because we can do this under duress of circumstances. And we have a duty under the law to distress the regime in any way we can. And particularly if they're stealing something from you or something, you have a right to defend yourself. But we never go in as the defendant. We always rebut that. But going in as the claimant, well, we can under those circumstances, you can use their rules against them even. So there are people out there doing this. I would personally suggest that anyone that goes into the magistrates' courts or the county courts is to do one thing: demand a properly convened court de jure for the matter to be heard. They can't deny you it. If they deny you it, then that's treasonable. So if we want to get this treason matter heard in a court, we're going to have to go after these people for treason. I mean, if they didn't want you to know about paedophilia, for instance, it wouldn't be all over the damn news. They want you to look at this paedophilia, don't look at the treason matter. Because there's a remedy there for us if we look at the treason matter. And that's what they don't want. That's why they're trying to subvert the Constitution, that's why they're trying to bring in a new Bill of Rights. So you need to really start looking at what they don't want us to... if voting did anything, they wouldn't let you do it. So come on, guys. This is a call to arms, a call to peace, not arms. But if we don't work this out in a peaceful manner, by using this process and standing together, we need to unite under the Constitution to protect it. Then we're going to be in a lot of trouble, and we're running out of time. Well, I just want to talk a little bit about Article 61. We use it as to the letter of the law, so we actually look at the words and act according to the words. So this is what we say when we say we use the law as to the letter of it. We also look at the spirit of the law, why it was there, what it's intended for, and it is intended for when the monarch is usurped or the country is being invaded in a treasonous manner. We've had tyranny in this country before, so this has been set up because we've had these problems before. This is the great thing about the British Constitution. It's been created over longevity through times of turmoil. Anyway, back to Article 61. In this article, it basically puts it down the process of how to remedy the matter, and it says that if we're not getting justice in our courts, or if tyranny is being allowed to reign, then a quorum of 25 barons are able to convene and to petition the monarch and to get redress from whatever grievance that may be. 40 days are provided, and incidentally, the Office of Sovereign responded in 2001 on the 39th day with an unsatisfactory response. But that gives a process for remedy to be made within a 40-day period, so that the grievance can be resolved, so that there's no civil war. Basically, this is what it's about. It's about keeping the peace. So Article 61, once it's been invoked, makes certain demands, and they are demands because it's probably the most important common law tenet there is. This is not like you can't. There's no fence sitting with Article 61. You're either standing and defending the country, or you're tacitly agreeing to the tyranny. There's no fence sitting. So it stresses in there that we have the duty or the right to seize castles, seize land, distress and distrain the monarch in any way that we should see fit, bar causing harm, physical harm to the monarch's being or their heirs or successors. And so this charter is kind of has equal consideration in it. This treaty, it says we'll provide you this remedy as long as you don't wage war against us and kill us. So it's a contract that we need to uphold. So we're not talking about going into Parliament building itself. We're going to come across a great deal of resistance if we do that. So we're acting on a local level, and we're asking people to act on a local level as well to address the councils and the police in your area as to that one question: where do you stand under Article 61? It's a very simple process. It gets them thinking, it gets them looking, and hopefully, well, it has to happen, that they'll come back on side of the people again when they realise that how they're being used. Once redress has been forthcoming, we are supposed to be loyal subjects, and I just want to explain that very briefly to the monarch again. Okay, now I accept my position as a constitutional subject. Okay, I do that because our rights and privileges, not privileges, our rights and inalienable freedoms are protected under the law. So under a constitutional monarch, my freedom, my right to justice is protected. So I don't mind standing under the common law. I consent to common law, do no harm, cause no loss, be honest and be peaceful. That's it. So anyone that doesn't want to stand under common law, really, I'm a bit suspicious of, because why wouldn't you want to do that? Right, so finish up, I'm just going to promote the Practical Lawful Dissent Facebook group again, and we've got a great website, lawfulrebellion.info, so you can get all the information that you require on those two places, and please come along, and you'll get good responses from the admin.